Good morning.
Thank you, Your Honor. May it please the Court, my name is Stuart Graham, counsel for the defendant, Sean Jenkins. This is Mr. Jenkins' combined appeal from his conviction for first-degree murder and from the denial of his motion for a new trial. This was a circumstantial evidence case, which there was no direct or forensic evidence linking the defendant to the crime scene, and there was no admission of guilt by the defendant. Lacking that evidence, the prosecutor engaged in misconduct in the examination of the witnesses in his closing argument, and that was assisted by ineffective assistance of counsel, as well as the introduction of prejudicial hearsay. I will address first the failure of defense counsel to impeach the Commonwealth's most important witness, a witness the Commonwealth said in a pretrial hearing that it could not ethically proceed to trial without. This witness made a false but material change in testimony, which the prosecutor failed to correct or to disclose to the defense counsel. During the examination of and I apologize, I'll call him Craig because there are three Jenkins. There's the defendant, Sean Jenkins, there's the victim, Stephen Jenkins, and there's this witness, Craig Jenkins, all cousins. During the examination of Craig Jenkins, prosecutor directed him to an alleged argument he had with the defendant during a telephone call where he told the defendant that he was going to testify before the grand jury. The defendant purportedly got angry. Prosecutor then asked what was said during that argument. Craig testified that the defendant told him to mind his own business and, quote, "You don't want the same thing to happen to you that happened to him."
Now, the Commonwealth says there were two telephone conversations and that what was testified to at trial was, I believe, the first of the two, but it could have been the second. I don't remember which the order was, but just one of them, in other words, and not both of them, and that the statement that the difference was that the statement in the grand jury was in the other conversation.
I don't think that's supported by the record. In fact, it's directly contradicted by the grand jury testimony, in which there was one telephone conversation, then there was a message left on the machine. But it was during the conversation that he testified at the grand jury, and he was directed to that conversation at trial. So it was one conversation. And I think that is clear from the grand jury minutes.
Okay, my next question is, do you think, assuming that you are correct about that, if I understand correctly, one is the defendant saying, you don't want to have happen to you what happened to Stephen, and the other version is Craig saying, I don't want you to do, is that right? I don't want you to do.
You're not going to do to me
what you did to Stephen. At which point he hung up, right? Defendant hung up.
I'm not quite sure. I think they may have had some other conversation, but he could have hung up at that point.
I think the testimony was that he hung up.
He could have hung up at that point.
And I guess my question is, yes, they're different, but are they really materially different?
Oh, they're materially different. The statement by Craig Jenkins is his own supposition, his own accusation. The statement by the defendant is a direct admission of murder and a threat of attempt to do murder. Very different, very prejudicial, very compelling, and very false. And that is the prejudice in this case. Defense counsel didn't impeach on that, although he had the grand jury testimony, and he could have. He stated in his affidavit that he, quote, overlooked that inconsistency. That ineffective assistance of counsel was compounded in this case because the prosecutor failed to disclose that change. The court is aware of the prosecutor.
You say it's a change. I mean, the change was as apparent to the defense counsel as it was to the prosecutor. The defense counsel had the grand jury. So, I mean, I don't understand what the prosecutor, in terms of Brady, I don't understand what the prosecutor would have needed to disclose. That he testified differently than he did in the grand jury?
That he testified differently, yes, and that it was false, both.
So you're saying that every time a witness at trial testifies differently from the grand jury, when the defense counsel has the grand jury testimony, the prosecutor is obliged to say, defense counsel, I want to alert you to the fact that this is different from what he said in the grand jury?
Your Honor, I believe I characterized this as a material change in testimony.
Well,
That is the law. It's a
Let's assume
material
it is.
change.
Let's assume it is. Are you saying that a prosecutor's obligation after the prosecutor has given the grand jury testimony is to then alert the defense counsel during the course of testimony that, oh, by the way, this is, turn to page 36 of the grand jury testimony and you're going to find that what he said on the stand differs? I mean, that's supposed to be part of the Brady obligation of a prosecutor?
Well, according to Commonwealth v. Vaughn, yes, it is. This is no different than the prosecutor giving to the defendant a witness statement. The witness then gets on the stand and says something materially different. He's required to disclose that beforehand. That's Rule 14, that's Commonwealth v. Vaughn. I'm sorry, Your Honor.
If he knows that, I mean, is there any indication here that the prosecutor in advance knew that there was going to be this switch?
Yes, I believe so. First, the prosecutor directed him specifically to this conversation. Second, the prosecutor had the grand jury minutes with him. And in fact, about 2 or 3 questions later, he refreshed Craig Jenkins' testimony with those grand jury minutes 1 page further on. That is, this statement is on page 36. He used the grand jury minutes to refresh Craig's testimony from page 37. To say that he didn't know what was in those grand jury minutes is beyond belief. Clearly he did. Secondly, we raised both of these issues in our motion for new trial. There was no affidavit from the prosecutor denying that this was purposeful, denying that he knew this. He remained silent on that throughout the proceedings below. So yes, I do believe there is some rather convincing evidence the prosecutor knew this, and he was required to disclose it.
Can I ask you, if there had been impeachment by defense counsel, would that have obviated the Brady problem?
No, it would not have obviated in one sense, Your Honor. It would have made it non-material because had he brought out that difference and used them effectively, then yes, he could have addressed that issue and probably would not have been a Brady violation. However, since he did not do that, his failure doesn't weigh against the prosecutor's obligation to provide that information beforehand, as the court held in Commonwealth v. Duceri and Commonwealth v. Vaughn.
Well, let me just explore one other aspect of this. If the prosecutor had disclosed it in advance, could defense counsel, depending on how, what the lead time was, could defense counsel have moved to exclude it on the grounds that it's late disclosure, that it's a late disclosure?
It depends when he would have done that. Had he waited until just before the witness gets on the stand, I would have moved to do that, yes, and I think counsel would have.
So there's a difference
But
between...
pre-trial.
So there can be a difference between obviation by impeachment versus a motion in limine that precludes it from coming in at all.
I would think so. If he follows the rules, Rule 14 requires he discloses pre-trial. If he does it then, he follows the rules, then at that point defense counsel can say, look, either I can deal with this with the grand jury minutes or I need a continuance in order to do some further discovery. That's his options once it's disclosed. That's why Rule 14 says, you disclose this pre-trial. If you wait just before he's going on the stand, he's not prepared for that in his defense. He can't construct an effective cross-examination at that point. At that point, I think moving to exclude it is proper.
But I mean, as Justice Gantz was saying, if you're prepared to defend, you're prepared to impeach with any prior inconsistent statement. And the guy had it right in his hands.
One would think so. That's why I say this is ineffective assistance of counsel. He had the grand jury minutes there. He should have been familiar with them. He should have known this was an important statement. He should have known that, and he should have impeached him. However, on the other side, the prosecutor also knew that this was an important statement. That's why he changed it, to make it even more compelling. He had the obligation both to correct it because it was false, and two, to disclose it because there was a material change in testimony. I would note that although we raised both of these issues in our motion below, the trial court addressed neither of them in its decision denying the motion for new trial. The prosecutor's closing argument, I think, continued this creative trial practice. first two critical misstatements going to the heart of the case. Miss Heinen was the closest thing the Commonwealth had to an eyewitness. She'd seen the car out in front of her house with two men in it. She went in the house, she heard a shot. She looked out, saw the driver slumped over the car, called the police. She testified that she saw two men in the car, the driver, a bigger, older man looking straight ahead, and the passenger, younger and smaller, who was acting nervous. She specifically could not identify either man. That was clear. Thus, neither she nor anyone else placed the defendant at the crime scene.
But she gave a description of the younger man as thin, didn't she? Younger and thinner? And
Younger and smaller, I believe.
Young and smaller.
Smaller.
Did she say about 15 years younger or
Yes.
something like that? And she said she saw him rising up and down in the seat as if they were in an argument. Didn't she
No,
say?
I don't believe so. She said she saw him looking around nervously.
They made eye
and looked at
contact.
her.
Yeah, I thought
But I don't think there was any testimony by her about like they looked like they were in an argument. I don't believe so.
Right, and I gathered that Ms. Heinen never said that's the man who was the
She
passenger
never
in the
identified
car.
the
But I mean, if you look, I mean, I've looked at the closing. As far as I can tell, you're complaining about the paragraph which said, Ms. Heinen's testimony was that the driver of the car, Steve Jenkins, was looking straight ahead, driving along, not paying any attention to her, in stark contrast to the defendant, looking nervously, looking all around, looking at her 5 to 10 times. That doesn't suggest to the jury that she had identified the defendant as the individual. It suggests that the Commonwealth is inferring that it was the defendant who was in the... I don't see the risk here that a jury is going to take that statement and say, oh, she must have identified the defendant as the passenger?
Well, Your Honor, there's a difference between saying you can infer this and saying this is what the witness said.
But that passage, he first describes Ms. Heinen's testimony and doesn't say anything about...
36 pages earlier, he gives the correct
Yes,
testimony.
and then he goes through all the evidence that sort of points out that this was the defendant, and then, as Justice Gant says, the inference would be that that was the smaller, younger man.
But that's not what he argues, and that's not what he says. That is, he doesn't say, you can infer the driver was Mr. Jenkins, the passenger was this. That's not what he said. He said, Ms. Heinen's testimony was that the driver of the car, Steve Jenkins, was this, and that the defendant was doing something else. That was not Ms. Heinen's testimony. That places the defendant at the crime scene based upon the alleged testimony of an eyewitness. That's not true.
But essentially you're saying that what the ADA should have said was not paying any attention to her in stark contrast to the man sitting in the passenger seat, who you can infer from the evidence was the defendant, who was looking nervously. I mean, is that what it comes down to?
It comes down to the prosecutor having an obligation to be truthful about what a witness
But,
says.
but it's one thing to say, if the prosecutor had said Ms. Heinen identified the defendant as the person in that car when that's not true, versus this statement, which I would think a jury would understand to be the inferences from the evidence as opposed to her eyewitness testimony.
Well, I'm not sure that we can ascribe that to the jury at all, since none of us know what the jury believed or didn't believe. But we do know that this prosecutor, at the end of the summation, said, this is what this witness's testimony was. And it's not true. It's not what her testimony was. He's not arguing inferences at this point. He's arguing what the direct testimony was. Now,
But why isn't that the sort of like a logical progression, beginning with what the prosecutor had correctly stated 36 pages earlier? Why isn't it just a logical progression of the Commonwealth's case?
had he argued that, that would be fine, Your Honor. It's what he should have done. But he didn't argue that. All of the suppositions, well, it could be this or it could be that, are not here. That's not this case. That's not this record. That's not his statement. His statement was what this witness's testimony was. That's the problem. He didn't say you can infer from the evidence that Mr. Jenkins was the driver and the defendant was the passenger. That's fine. But to say that the witness testified to that, that's error. That's wrong. That's the problem with this testimony. This is followed by the testimony of Ms. DeMiranda, who was a defense witness. There had been a Commonwealth witness who said that The defendant had threatened Ms. Miranda with doing the same thing to her as he did to Steve, the victim. Ms. Miranda was cross-examined on direct examination and on cross-examination, denied that. Under direct cross-examination by the prosecutor, said, "Are you absolutely certain he didn't say that?" She said, "Yes." "Are you adamant he didn't say that?" She said, "Yes." Nevertheless, in closing arguments, he says that this witness, who wasn't a friend of the Commonwealth, quote, said that this defendant admitting doing what he did to Steve. Again, putting into the mouth of a defense witness, favorable to the defense, a statement that the defendant admitted to her that he murdered Steve. That's prejudicial. That's not a slip of the tongue. This is a prepared closing argument. These are not just slips of the tongue. These are things to put in order to prejudice the individual. The same as in Craig's change of testimony.
Well, counsel, did the judge give the standard charge to the jury about counsel's argument is not evidence and that it's your memory of what was testified to that controls and so forth?
That's all he gave. And in Commonwealth v. McLeod, the court held that that charge is not a curative charge. It is ineffective to address these kinds of errors in closing argument. And so there was no curative instruction by the judge. Also in the closing argument, move beyond these misstatements, we have improper exhortations to the jury, both at the beginning and the end of the testimony, where the prosecutor said that this man exterminated his cousin, and justice and the evidence demands he be held accountable for that. At the end, he says, "I ask you to return the only verdict that justice and the evidence and the overwhelming evidence of the defendant's guilt demand." Now, I think, as Justice Ireland, as you wrote in Commonwealth v. Torres, those kinds of exhortations to the jury, those kinds of calls to do justice, those kinds of saying that you can do your duty only by convicting, because that's what justice demands, are improper. Improper here is just a polite word for misconduct. This was misconduct. Prosecutors need to understand what the rules are. I think Justice Brown, I cited in the brief, said it's time that the courts hold the Commonwealth to the requirements, to the rules, and make them abide by. This was one of the most improper closing arguments I've seen from beginning to end. In the middle of these bookends of improper exhortation, the prosecutor continually aligned himself with the jury and continually interjected his personal beliefs to the defendant's guilt. That was this improper argument. And all of these errors have to be considered cumulatively, not singly as the Commonwealth does in its brief, but cumulatively along with other errors in the trial. I would note here, in this trial, we have an improper closing argument. We have prejudicial hearsay coming in, just in a moment. And we have an improper impeachment of a witness. Those three things combine in Commonwealth v. Clinton to create a substantial risk of a miscarriage of justice. Same things are here. The same risk, substantial risk of a miscarriage of justice.
If you could move to the prejudicial hearsay, specifically the barbershop statement of "you don't want to do that here."
Right.
Well, why is that offered for the truth of the matter asserted?
That's the way the Commonwealth offered it. The Commonwealth argued it in closing argument.
But it's not. I mean, what truth is there? You don't want to do that here. What is the truth of the matter being asserted that would make that to be a hearsay statement?
You don't want to shoot him here is what he was saying, Your Honor. And there is no way for the defense to defend against that. As they argue in the brief, not only does that not come within any hearsay exception, it also violates the defendant's right to prepare or present a defense. You can't defend against a statement. This is by a biased witness who's sitting in a car at night looking over his shoulder at a group of men some distance away, and she says a cohort of the defendant, remember this is the victim's girlfriend, said, "You don't want to do this here." How can you defend against that? There was no indicia of reliability. It met none of the requirements for an excited utterance. It was not an adopted admission, as the Commonwealth now argues.
Question of what is the truth of the matter that's being asserted?
That he has a gun which is how she prefaced this.
That's not
And
what-
he's showing you the gun and that he is going to shoot the defendant. That's the implication. That's why this was offered.
I
That's why it's
I
prejudicial.
understand the implication, but do we look to the implication of a statement, or do we look to the statement itself? to
Then
determine
if you
whether
look
it's
to
hearsay?
both. You have to look at what the prejudicial impact of the statement is. They offered this for the truth. That is, this is what the man said, and the truth is, you don't want to do that here. This is not, if it's not offered for the truth, Your Honor, why is it being offered? Its prejudicial impact outweighs any relevance. So if you're not offering it for the truth, there's absolutely no relevance to it. So either way, it shouldn't come in.
Mr. Graham, we'll have to leave it there.
Thank you, Your Honor.
Thank you.
Good morning, Your Honors. May it please the Court, Hella Saxa on behalf of the Commonwealth. This Court should affirm the defendant's conviction for murder in the first degree. With regard to the first issue I briefed, the defendant properly waived his right to testify here. Judge Conley discredited the defendant's affidavit and the affidavit of trial counsel and said that after the colloquy that he conducted with the defendant during trial, and after all the observations he made of defendant and his attorney, he did not see any disagreement, and he thought that the defendant had properly waived his right to testify.
Could I ask you on a different subject question? I want to go back to something that Mr. Graham raised, and that is the issue of the Craig Jenkins, the two conversations. And I think you say in your brief that there was nothing improper or no ineffective assistance in any event, that there was no inconsistency here because the testimony at trial was referring to one conversation and the grand jury minutes had referred to two, correct?
That's correct, yes.
Well, I've read at least I think I've read the portion of the grand jury minutes that you indicate, and I didn't see, yes, there was a reference you could infer to two conversations, but certainly the statement that was Mr. Jenkins made at trial didn't appear in either conversation, at least at the grand jury level. I didn't think, but maybe I'm not
That's
looking
right.
at the right place.
If I might preface this area of argument with the fact that Judge Conley had the opportunity to review all these ineffectiveness claims at the motion for new trial, and that he was very specific and said that defense counsel did a more than satisfactory job of impeaching Craig Jenkins. Anything further for impeachment would be mere surplusage. Although counsel says the judge did not specifically address this particular issue, I suggest that the record indicates that trial counsel here went for impeachment on sort of a bigger picture. He just tried to show Craig Jenkins as an imposter, as someone who dressed in a clergy collar, came into court pretending he was a man of the church, and who turned out to be a liar and a fraud. And counsel's...
But try Justice Botsford's question,
Of
which is
course.
where in the grand jury testimony is this statement you assert is the second statement? I couldn't find it either.
I believe that the testimony in the grand jury was, during the grand jury, Craig Jenkins referenced the first conversation during which they had a big fight. And then he says, the defendant called me back, and I quote, he left a message. He tried to clean up the fact that he and I had just had a horrible argument when he called me when we were arguing. I said to him, I ain't Stephen, man. I said, you ain't going to do to me what you did to him.
Right.
Right.
I read that as
and-
referencing the second conversation that they had.
Right, but before that, in the grand jury minutes, there's a testimony about the first conversation.
That's right. And
it
during
doesn't
trial,
have-
during trial, that's what what Craig Jenkins testifies
Yeah,
to.
but in
Okay,
that,
but the grand jury doesn't have anything, a statement that says that the defendant said, I'm going to do to you what I did to Stephen.
It's not in there, and I think it's the prosecutor asked Jenkins based on the grand jury testimony about his conversation, and the witness simply testified differently from the grand jury.
Okay, but you told us it was in your brief you say it's in the grand jury testimony, and now you say it's not.
I believe in my brief I say that the fact that that there are two conversations is in the grand jury.
Well, there are two conversations. I understand that, but the first conversation, as far as I can tell, is where the defendant says, "I didn't effing do nothing." You got Craig saying, "I said to him, I said, you should have never did what you did." He said, "I didn't effing do nothing." He said, "If I were to effing kill that boy, I'd be locked up by now." That seems to be a denial, not an admission.
The prosecutor simply questioned the witness about this conversation. And if the witness's testimony at trial is different from what he said in the grand jury, it is not something the prosecutor can foresee or in any way disclose before it happens, because he simply doesn't know.
That's a different point. It's what you've represented in your brief that I think we're troubled by, because it just isn't here.
I'm sorry if my brief is unclear on that point. I did not intend to misrepresent anything. My reading of the...
It's clear on the point. It's just wrong on the point.
I apologize.
All right. Can we turn to the closing argument?
Of course.
Is it? You also said that on page 58 of your brief, you says the Commonwealth. You said that the ADA never said the evidence was overwhelming.
That is incorrect.
Right. Because on page 48 of the brief, you cite him saying
that's
it's
right.
overwhelming.
Yeah. On page 141 of the closing of volume 8, the prosecutor said, based on this overwhelming evidence. Yeah,
okay, and is it your view that the prosecutor's closing, saying the evidence was overwhelming, saying that a guilty verdict is the only verdict that justice that you could possibly give, that's an appropriate closing argument?
Yes, it is. First of all, the closing argument was never objected to, and immediately following, without even a break in the proceedings, the judge instructed the jury that they were to use their own recollection of the testimony.
Okay. The question is not whether the error created a substantial miscarriage of justice. The question I have is whether that was error. Are you saying
no, it wasn't.
It was not error?
Based on what the prosecutor here did is he never used the word justice by itself. He always connected it with evidence. At the beginning of his closing, he said, "Justice and the evidence demands," on page 102. Then he goes through in detail through all the evidence that has been presented to the jury, and then comes back in on the very last page of his closing saying, "The only verdict that justice, the only verdict that the evidence, the only verdict that you could possibly give based on this overwhelming evidence of the defendant's guilt, I ask you to find him guilty."
And isn't that telling the jury that they're not doing their job as jurors if they don't find the defendant guilty? Isn't that precisely the concern we have for that kind of a closing?
No, I think this sentence, it indicates that he is urging the jury to convict the defendant based on the evidence that has been presented. And this court, I know, has said that the word overwhelming using the word overwhelming is not favored, but even in Tuit, where the court addressed this, 393 Mass 801, the conviction was not was affirmed. So it's one word in 41 pages of closing that is factually very intense, in which the prosecutor goes through every detail of the facts and lays it out for the jury.
If we could turn to the testimony of that the hearsay statement of Stephen don't know Sean will kill his ass. How does that come in?
I suggest that it is admissible as an adoptive admission, because it was said by the defendant's girlfriend in the car when Craig Jenkins, Sean Jenkins, and Kenitra Newton were all sitting in the car. And
isn't an adoptive admission usually about something that has happened? This is a an opinion of what something might, I mean, how do you get there?
Well, even if it was not admissible, the defendant had minutes earlier said the same thing to Craig Jenkins. He and Craig were sitting in the car, and the defendant told Craig repeatedly, "I'm going to kill that dude. I tried to buck him. The gun jammed. I'm going to erase him." The girlfriend comes in and she says, Stephen don't know Sean. Sean will kill his ass.
Okay. Well, I guess the other question I have is, do you agree that for it to be an adoptive admission, the adoption is the defendant's silence?
That's correct.
Which means there must be testimony that the defendant was silent in response to that statement.
Yes, Craig Jenkins testified the defendant was upset and that he did not recall whether he said anything.
So if he doesn't recall whether or not there was any response, how can the evidence be that he adopted that, because we don't know what he said in response?
As I said, even if it was not admissible, the same information was properly admitted, properly testified to, based on a statement by the defendant himself to Craig just a couple minutes earlier before the girlfriend returned to the car.
If I could turn to the questioning of the defendant's mother regarding the gun with respect, I gather there was some police report which the ADA was using to question the defendant's mother. Am I correct?
The document is not officially in the record. I assume it is a report of an interview between the homicide detectives and Mr. Hooker. That document was disclosed to the defense as number 41 on the second discovery.
But how do we know that you argue, and you may be right, that the prosecutor had a good faith basis to ask that question.
That's correct.
And the good faith basis, I assume, would come from that interview report. But how are we to examine whether or not there was a good faith basis based on the report without having the report as part of the record?
I think in this case it's not necessary to have, first of all, no, it's not. The report is simply not in the record, but it was disclosed.
Was it offered as an exhibit for the marked?
No, it was not. It was simply used to refresh the mother's recollection. And she had testified, first of all, that her relationship with Mr. Hooker ended on good terms. That's when the prosecutor, intending to impeach her with the information he had from that statement, pressed her further and finally ended up trying to refresh her recollection. He also questioned her, did you ever hold a gun for the defendant, to which she answered in the negative. And then he shows her the document, and the questioning ends at that point because the court day is over. And the next day, he does not resume questioning based on that report. So here the jury is left with the mother's statement saying, I never held a gun for my son. And all the jury heard about the rest of the statement is that her relationship with her ex-boyfriend ended in a restraining order, which I think is simply irrelevant to the facts of this case.
Did the defense counsel object and say that there was no good faith basis for the questioning of the mother?
He did not object on those grounds, and he couldn't have because he had the document.
Okay, so basically that there was no objection, and therefore no reason for the ADA to come to sidebar and say, here's my good faith basis for
Well, he did make that.
He did when?
He went to sidebar saying, I do have a good faith basis. I don't think he necessarily...
The defendant's objection was relevance, wasn't it, I think? I'm not sure. I didn't think it was good faith basis, but I could be wrong.
Oh,
I'm agreeing with you.
I'm not sure right now on what grounds he objected to this. Anyway, at the end of the day, the jury was left with a statement from the mother saying, I never held a gun for my son. And so I don't think that there can be any prejudice from this section of the testimony.
barbershop hearsay. You don't
Yes.
want to do that here. Are you arguing adoptive admission, or are you arguing spontaneous utterance, or are you arguing that's not hearsay at all, and therefore hearsay doesn't apply?
Well, the prosecutor attempted to introduce that statement as an excited utterance, and he laid a foundation when Tamisha Miranda testified that she heard one of the defendant's companions scream, and that he looked scared and had a scared expression on his face, and that then she heard him say, "You don't want to do that here." I think it's perfectly admissible as an excited utterance, and the foundation was laid. The key part of the testimony about the barbershop was Tamisha Miranda's observation that the defendant removed a gun from his pocket. And the "you don't want to do that here" could refer to a number of things. It could refer to simply the removal of the gun, the display of the gun, or to the intent to kill the defendant, to kill Stephen, I'm sorry. The defendant told Craig Jenkins shortly after this incident that he had tried to buck that dude in front of the barbershop and that the gun
Do
jammed.
we know what that means, buck that dude?
I think in conjunction with, but the gun jammed, I think it refers to at least shooting at Stephen, if not the intent to kill him.
That's, how do we know what buck means? You're saying in context of everything else?
Right.
That it
He
means
said-
do harm?
Exactly.
Okay.
He said, "I try to." Used expletives. I tried to buck that dude, but the gun jammed. I think he needed an operable gun to do what he intended to do, and I think that can only refer to using that firearm on Stephen. Quickly to the remainder of the closing argument, I suggest that this closing was entirely proper. The prosecutor laid out all the evidence for the jury. Counsel's...
He erred as to Dia de Miranda, did he?
I suggest it is a slip of the tongue. If these two witnesses, Dia de Miranda and Doreen Fernandez, factually always appear as a pair throughout the entire case, and I submit that he simply intended to say Doreen and instead said Dia.
But it is the fact that it was just Ms. Miranda who testified for the defendant, correct?
That's right, yes. She was the only defense witness, and Doreen Fernandez testified for the Commonwealth. If her name is inserted in that place, the prosecutor's statement becomes entirely clear, and he would have no reason to tell the jury that a defense witness was not particularly cooperative with him. It just becomes much clearer if he would comment on a prosecution witness in that way. The use of personal pronouns that the defendant challenges here also was entirely proper. The defendant refers this court to Commonwealth v. Birds, 68 Mass 684, in which the appeals court criticized after finding the prosecutor's closing argument improper with regard to a different issue, simply stated, "We're troubled by the use of these pronouns," without referencing any cases or talks about their concern of these pronouns. However, this court has said in Commonwealth v. Espada, 450 Mass 687, that the use of personal pronouns does not interject personal belief, and in a court out of the D.C. Circuit, Crutchfield versus United States. The court specifically addressed this issue and said prosecutors' closing argument, replete with the use of we and us, was proper. Again, here, as in Burt's, there was no objection to the closing, and Burt's was affirmed, and this court should also affirm the defendant's conviction.
Can I just ask you one factual question?
Of course.
The report you're referring to that was presumably an interview with Mr. Hooker,
Yes.
is that something, and you've said that trial counsel, defense had it, is that something that Mr. Graham would have has as well? I mean, I could ask him, but I just don't know if that's part, I know it's not part of the record before us, but I am wondering if it's
I would assume
available?
that Mr. Graham received the entire trial record from trial counsel, and it would have been part of that. It was number 41 on the second discovery notice by the Commonwealth. So he should have.
Okay.
I think he should have had it. Yes.
Thank you, counsel.
Thank you very much.